whether an LLC, limited liability corporation, must be represented by an attorney on appeal. Well, can the corporation just have one of their workers file the paperwork? Usually an individual person can file their own appeal. But what about a corporation? They never talked about this in law school. Let's see who the attorneys are. Pro se for defendants and appellate. Okay, the manager of Rustic Homes decided he was going to file himself. Well, I don't know how big a corporation that is. Let's see what it says. Background. Rustic Home Builders, LLC, contracted with Michael and Maggie Smith to provide the Smiths with specialty lumber products, services, and log home supplies for constructing a home north of Flandreau. It's over there by Sioux Falls. Disagreements eventually led to a lawsuit. On May 1st, 2007, the Smiths obtained a default judgment against Rustic for roughly $175,000. At May 1st, 2007, keep our dates straight. This is a 2013 case. The default judgment against Rustic was executed in Iowa in 2007. Okay, it's another 2007 date. Okay, let's go back. Do I see any other dates? Oh yeah, it's down here. October 25th, notice of appeal served. April 11th, temporary restraining order. Okay, let's go back. Although Jay Drysden, Rustic's manager, and Jared Drysden were listed as individual defendants, the default judgment was only against Rustic Home Builders, LLC. Rustic and Jay Drysden moved to set aside the default judgment, but the motion was denied. The default judgment against Rustic was executed in Iowa in 2007. Almost 5 years later, in March 2012, the Smiths and Rustic stipulated that the judgment had been partially satisfied based upon the Smiths' seizure of truckloads of logs from Rustic. A partial satisfaction of debt was entered for about $45,000. In April 2012, the trial court issued an order that the claims against Jay Drysden, which if proven would allow for the piercing of the corporate veil, may be dismissed without prejudice. The order went on to state that any other claims against Jay Drysden presently made or presented in the future arising from the facts or circumstances which gave rise to this case other than the previously entered money judgment were dismissed with prejudice. So we have part dismissed without prejudice and part dismissed with prejudice. So with prejudice means they can't file again. Without prejudice means that they could file that part of the lawsuit again. Later, Rustic unsuccessfully challenged the amount of the partial satisfaction of judgment, arguing that the entire judgment had been satisfied. Huh, okay. So there's 45,000 and 174,000 or 175, so it's like 130,000. He's claiming it was all, entire judgment was satisfied. I'm not sure that's all relevant to the issue in the case, but they're giving us the facts. So let's see later if it's relevant. On October 25th, 2012, J. Drysick individually and on behalf of Rustic served and filed a notice of appeal. So I don't know how he can act on. Now it looks like one guy was acting on the behalf of Rustic and then the other guy. Is that true or no? Yeah, the other guy's the manager. Dreisen is not a licensed attorney. The notice provided that Dreisen and Rustic sought to appeal the April 11th, 2007 temporary restraining order, the May 1st, 2007 default judgment, the June 12, 2007 order denying setting aside the default judgment, and the September 18, 2012 partial satisfaction of judgment order. Sounds like he wants more money. Let's see, partial side. I'm not sure which side of the issue he's on there. It doesn't say. The Smiths moved to dismiss the appeal, asserting that, number one, the appeal is untimely. 2, Dreisen is not an attorney, cannot represent Rustic. And 3, Dreisen is not an aggrieved party. So, yeah, I understand their issues. Okay. Analysis and decision. Untimely appeal. The Smiths argue that portions of this appeal are untimely. South Dakota Codified Law 1526A6 provides that an appeal from a judgment or order must be taken within 30 days after the judgment or order shall be signed, attested, and written notice of entry thereof shall have been given to the adverse party. If the party is served by mail, 3 days shall be added to the prescribed period. Okay, we have no jurisdiction over an untimely appeal. There's the citation. Failure to serve a notice of appeal on a party before the time for taking appeal has expired is fatal to the appeal and requires its dismissal. Dreisen and Rustic appeal 4 separate orders. 3 of these orders are from 2007. The April 11, 2007 temporary restraining order, we would have thought that would have been done by now. The May 1st, 2007 default judgment, and the June 12, 2007 order denying setting aside the default judgment. Because each 2007 order is at least 5 years old, this court is without jurisdiction to consider Dreisen and Rustic's appeal of those orders. Accordingly, the appeal of the 3 2007 orders is dismissed. Well, yeah. You know, I wonder if them filing those, which any attorney wouldn't have filed, prejudice the court against them. We'll see. Actually, we wouldn't be able to tell, but sure looks bad. Okay, representing of an LLC. The appeal of the September 18, 2012 partial satisfaction of judgment order is timely. Nonetheless, the Smiths argue that Dreisen, a non-lawyer, cannot appear on behalf of Rustic. As a matter of first impression, we consider whether an individual may appear pro se to represent an LLC. Well, if so, if one of them could, then the other one could too, right? So who's to say who the lawyer is if they're both? So okay, anyway, this guy did. In South Dakota, a director, officer, or shareholder of a corporation who is not a licensed attorney is not permitted to appear pro se to represent a corporation. Although a limited liability company is not a corporation, it is like one in being distinct from a natural person. Accordingly, many courts have extended the rule that a corporation must be represented by a licensed attorney to LLCs and thus require an LLC to be represented by a licensed attorney in legal proceedings. The view that an LLC cannot be represented pro se is sound, given that the right to conduct business in a forum that confers privileges such as the limited personal liability of owners for tort or contract claims against the business carries with it obligations, one of which is to hire a lawyer if you want to sue or defend on behalf of the entity. I don't know that might be circular reasoning. We agree, so one would have to go to that Hagerman case and read more depth to see if that is a circular argument. We agree with other courts that have addressed this issue and hold that a non-licensed attorney is not permitted to appear pro se to represent an LLC. Therefore, Rustic's appeal of the September 2012 partial satisfaction of judgment order, which was filed by its manager and non-lawyer J. Dreisen, is dismissed. Agreed party. All that remains is Dreisen's individual appeal of the September 2012 partial satisfaction of judgment order. The Smiths argue that Dreisen is not an agreed party and therefore, and accordingly cannot appeal this order. As a general rule, an appellant must not only have an interest in the subject matter in controversy, but must also be prejudiced or aggrieved by the decision from which he appeals. You see, this was against him too, so now they're talking about the part that he does have standing to represent himself. The trial court's order from April 2012 dismisses without prejudice claims against defendant J. Dreisen, which, if proven, would allow for the piercing of the corporate veil. In the same order, all other present or future claims against Dreisen does not relate to the previously entered money judgment were dismissed without prejudice. Therefore, because all the claims against Dreisen were dismissed, he is not an aggrieved party and cannot appeal the September 2012 partial satisfaction of judgment order. Okay, if all claims against him were dismissed, then yeah. So what? Yeah, remember I said I didn't know which side of the issue he was on? He must have been trying to stand up for the corporation there. And he didn't have standing to do so? Would that be an issue? Interesting. He didn't have standing because he was an attorney? He didn't have standing for any other reason? I'm just musing about some other issues that are not delineated in this case. Well, that was interesting. So, the answer is yes, an LLC must be represented by an attorney on appeal. Well, probably even before appeal. I don't know that, but this is only talking about an appeal. I guess if he went down and filed a lawsuit